She coming.
So that's fine. No.
Okay, I mean, whatever it is, it'll be fine. Cutting that off, maybe those last two officers will be fine. If you're okay with it. Good morning. The November the 9th, 2016 meeting of the Board of Estimates is now called to order. In the interest of promoting the order and efficiencies of these hearings, persons who are disruptive to the hearing will be asked to leave the hearing room immediately. Meetings of the Board of Estimates are open to the public for the duration of the meeting. The hearing room must be vacated at the conclusion of the meeting. Failure to comply may result in a charge of trespassing. Madam Deputy Controller, are there any corrections, additions, or deferrals on the agenda?
Good morning. First, I'd like to announce in the absence of the Honorable Mayor Rawlings Blake, Mr. Henry Raymond will act on her behalf. I have some changes to announce. On page 72, item number 3, for TR 17012, under the description on the third line, it currently reads Northeast Sector 2. Please change Northeast to Northwest, so that would read Northwest Sector 2. On page 73, item number 5, for TR 17013, in the description on the third line, it currently reads Northeast Sector 3. That should be Southwest Sector 3. The board received a protest for pages 71 to 72, items 1 and 2, 72 to 73, items 3 and 4, 73 to 74, items 5 and 6, from M. Louis Construction Company. A response to that protest of M. Louis Construction Company was received on behalf of P. Flanagan and Sons. I have 2 items that are being deferred. Pages 135 to 136 for 1 week, and pages 79 to 125 for 1 week. As the board will be in recess, the actual date will be November 23rd, 2016 for those 2 items being deferred. I have the following abstentions and no votes to report. There are no abstentions for the Honorable Mayor Rawlings Blake. The Honorable President Young will abstain on pages 127 to 129, page 130, and page 131, item number 1. In addition, the Honorable President Young will vote no on pages 13 to 14, item number 1. There are no abstentions for the Honorable Comptroller Pratt. Mr. Rudolph Chow will be abstaining on page 130. The items that are on the non-routine agenda are pages 71 to 72, items 1 to 2, pages 72 to 73, items 3 and 4, pages 73 to 74, items 5 and 6, and page 126. Mr. President, members of the board, those are the changes to the agenda, the protests received and the response to protests, the items that are being deferred, the abstentions, and the no vote that has been reported to me thus far. Thank you.
Thank you. I will direct the board members' attention to the memorandum from our office dated November the 7th, 2016, identifying matters to be considered as routine agenda items together with any corrections and additions that have been noted by the Deputy Controller. I will entertain a motion to approve all of the items on the routine agenda.
I move the approval of all of the items on the routine agenda.
Second.
All those in favor say aye.
Aye.
All opposed, nay. The motion carries. The routine agenda has been adopted. The first item on the non-routine agenda can be found on pages 71 to 75. Items 1 through 6, Department of Transportation. Recommendation for contract awards and rejections, TR 17011, TR 17012, and TR 17013. Will the parties please come forward? Okay, who's going first?
Good morning, Mr. Chair and
Good morning.
members of the board. Frank Murphy, Acting Director of the Department of Transportation. There are 3 contracts, resurfacing contracts that we're talking about, and there is a form that we've been using for about 3 years since the local hiring law had been passed. The form says on it that failure to complete it will result in a non-responsive bid being determined non-responsive. Accordingly, the Department of Transportation recommends that the contracts be awarded to the second bidder.
The second lowest bidder, Mr. Murphy.
Second lowest bidder.
Good morning, Mr. President. My name is Robert Fulton DeShield. I represent the lowest responsive and responsible bidder on all 3 contracts, M. Louise Construction. I'm joined today by the president and the person who's in charge of the Human Resources Department of M. Louise. Quite frankly, Mr. President and members of the board, I don't think I can better say standing here that which I've already presented to you in the protest that we filed. The fact of the matter is that that very issue was before this board in April of 2014. I remember that painfully because it was my case. And the board decided on that day, in response to questioning by the comptroller, questioning to Mr. Truss, the head of purchasing, the board decided that day that with respect to this precise issue, that a bidder who executes the bidder affidavit is bound by all applicable laws, including the local hiring ordinance. The board, that was less than as I say, in April. Then again, just a few weeks ago, the board awarded a contract, 17016, I think it was, where the statement, the one statement that Mr. Murphy referred to, wasn't even included in the bid documents. So it's pretty clear to me that on the one hand, every bidder, and it says so, quite frankly, in the bidder affidavit, every bidder who submits a bid agrees to be bound by all applicable laws, rules, and regulations. So whether they're included expressly in the bid documents or not. In fact, on the website of MOED, the Mayor's Office of Employment Development, which where the instructions are given and its description given of the local hiring ordinance, which in fact began with an executive order of the mayor, as amended and approved by this board, it specifically says that the bid documents need only incorporate by reference the local hiring ordinance, and that the execution of the bid documents by a bidder is, in fact, confirmation of its obligation to abide by those terms. That's not a new concept. It's been judicially affirmed. The decision that this board has made previously is absolutely correct on that point, and so the recommendation from Transportation to deny my client the award of these 3 contracts, where it was the low bidder, is not warranted, and we urge you to reject it and award the contract to the lowest bidder, M. Louise Construction. Thank you.
Thank you.
Good morning,
Good morning.
Mr. President, members of the board. Paul Kaola from Gallagher, Velius & Jones on behalf of P. Flanagan & Sons. With me is Pierce Flanagan, the president of the company, and other members of his team. The certification statement that was not executed by M. Louise provides complete and submit this certification statement with your bid package, and then has a mandatory statement that if you do not sign and return this statement, your bid will be considered non-responsive. That document is mandatory, and if public bidding is to mean anything, then the board needs to uphold mandatory statements of this sort, and failure to submit mandatory forms and find M. Louise non-responsive. Mr. DeShiel has pointed to a 2014 finding by the board. That was a completely different situation. And if you look at the transcript, and we've pointed it out in our response letter, if you look at the transcript, it is clear that in that case, the local hiring law was part of the bid package. And by signing the bid affidavit, the bidder was agreeing to all of the specifications, including the local hiring law, which was part of that bid package. In this case, the Department of Transportation did not include the local hiring law in the bid package. There was nothing in the bid package to indicate the bidder would comply with this particular law other than this certification. So by leaving the certification out of their bid, M. Lewis was not committing to comply with this law. Madam Comptroller made a comment, and we cite it in our response letter, but if you look at Exhibit 3 to M. Lewis's bid protest, the language of the bid affidavit says that the bidder agrees to comply with all of the specifications. So where the specifications include the local law, the local hiring law, then that's an agreement. That's good enough. But in this case, they didn't. The local hiring law is not part of the specifications, and the bid affidavit doesn't say that the bidder will comply with all laws, whether they're referenced in the specifications or not. So there is no commitment by M. Lewis to comply with the local hiring law. The local hiring law is not the same thing. M. Lewis cites to the Employ Baltimore certification, which was executed, but that only applies to contracts under $300,000. And M. Lewis's bid in each of these cases was over $300,000. So it has no application at all in a circumstance where you're bidding above $300,000. And signing that certification, there's a reason there are two certifications. The checklist that is attached to it as Exhibits 4, 5, and 6 to our opposition includes a checklist of every item that must be included with the bid. And one of them, I'm just going to direct your attention to the second page of Exhibit 4. It says complete the Employ Baltimore certification statement, and then parenthetically for contracts under $300,000, or it doesn't say and, it says or the local hiring certification statement for contracts $300,000, which should say $300,000 or above. But the point is, there's only one form that needs to be required, and there is no overlap between the two certifications. They were both included, and they're both included for a reason. If the bidder is going to bid under $300,000, they know which form they need to complete. If they're going to bid over $300,000, it's a different form. It's a different law, and they don't overlap. For these reasons, M. Lewis should be found non-responsive, and the lowest responsive bid belongs to P. Flanagan. The Department of Transportation was right to recommend award to P. Flanagan and Sons. Thank you.
David?
Yeah. Mr. Kaola, I agree with your presentation on the differences between the certifications. My question to you is, isn't a bidder obligated to follow or to adhere to any existing law that's on the books?
Yes, I think that bidders are required to comply with laws that exist on the books. But the reason that the Department of Transportation is including this certification is to bring this law to the forefront and to ensure that all bidders are aware of this law and are focused on complying with the law.
Okay, I'm aware of why the Department of Transportation wants to make sure that all bidders are aware of the law, but all bidders are imputed with knowledge of existing laws, correct?
That's correct.
Okay. And so what is the practical effect of not signing a document when you're otherwise obligated to adhere to the law anyway?
Well, the practical effect is that the forms are not correct. And as the mayor has pointed out in the past, particularly where the instructions to all the bidders are that if failure to submit this particular form will result in a finding of non-responsiveness, then I think it challenges public trust in the bidding process, because what is required to be submitted as part of a bid if in fact bidders are allowed to be awarded contracts even when they ignore the clear language of the bid package.
Well, I think, Mr. Kaola, the difference is in a bid package, there are plenty of terms and provisions that are not part of laws, correct? They're just terms and provisions of the bid. But when there are laws on the books, everyone is obligated to comply with those, whether they sign off on them or not. So again, when I ask what's the practical effect of not signing it, and you said, well, you went to the forms, isn't that the example of form over substance?
No, I don't think so. I think that if the Department of Transportation doesn't require this form to be submitted and doesn't indicate on the bid package that the bids will be found non-responsive if the forms are absent, then we're in that world. We're in a world where I don't disagree that if they didn't include the language that indicated the form would be non-responsive, then I think that would be a different circumstance. But I think that public trust requires that the Board of Estimates not overlook mandatory language in bid documents. I mean, the public is, and all of the bidders are made aware. There's clear notice that these forms need to be required. And for the Board of Estimates to do its own analysis of whether a particular provision that's mandatory, that's indicated as mandatory, is material or is not material, I think really creates confusion for the bidders.
So let me, that's the exact point that I wanted to get to. I agree with you that there is a defect in the bid documents, correct? That there was a defect by M. Louise. My question is it material? And if any bidder, regardless of signing the document or not, is required to do it regardless, is it material or is it immaterial, irrespective of the document?
I understand the question, and I think it is material because the bid documents make it mandatory and indicate that the bid will be found non-responsive if the form is absent. I think I don't think that's form over substance.
So doesn't that take away our discretion?
I believe in this case, the board should not have discretion to award this contract. If the board finds the bid documents to be to be defective, then these contracts should be rebid. I don't believe that the board should take mandatory language like this, where a bidder fails to comply, and nevertheless award a contract because of. I just think that creates confusion in the public bidding process.
Thank you. I appreciate it.
I entertain a motion.
I move that we reject DOT's recommendation for the second lowest bidder, that we award the bid to the lowest bidder based on the fact that the defect was immaterial.
Second.
All those in favor say aye.
Aye.
All opposed, nay. The motion carries. Thank you. The second item on the non-routine agenda can be found on page 126, Department of Finance, financial audits of the Department of Transportation. Will the parties please come forward?
Good morning. My name is Steve Kraus, Deputy Finance Director. Good morning, Mr. President, Madam Controller,
Good
Director
morning.
Raymond, and members of the Board of Estimates. In accordance with AM Policy 404-5, Quadrennial Audits Policy, the Department of Finance submits to the Board of Estimates the Department of Transportation Quadrennial Financial Audit for fiscal years 2010, 2011, 2012, and 2013. The Board of Estimates is requested to approve the financial audits. The audits received an unqualified opinion, meaning that the financial statements were presented fairly in all material respects, and the respective financial position of the governmental funds and the conduit fund for the Department of Transportation. I would like to note that in none of the financial audits completed to date have irregularities or fraud been found. Under Mayor Rawlings Blake's leadership, the administration has been fully supportive of the quadrennial audit process, and all 13 principal agencies are under contract either with Department of Audits or with external auditor. And all these will be completed by December of this year. Thank you.
Thank you. The audit has been noted. There have been no more business before this board. The board will recess until bid opening at 12 noon.
Good afternoon. The Board of Ethics is now in session for the receiving and opening bids. I have the following addenda to read. WC 1270, Water Infrastructure Rehabilitation, various locations. Please change the bid due date from November 9th to November 23rd, 2016. ER 4036R. Environmental Restoration Contract for Urgent Need Stream Repair 1. Please change the bid due date from November 9th to November 23rd, 2016. Those are the addenda for today.
Hearing no objection, so ordered.
Oh, samples. Yeah, I forgot what it was. Yeah, okay. Goes with this one. Excuse me. B50004600. Various gloves. A bid bond is not required. They're not bidding for everything. They should. Yeah, because I don't see anything for the, what was that number 4? Maybe it is. Here's number 1. Well, I don't see a price for 1. I see one for 2. Wait a minute. Maybe they are doing it. I'm going to read the bottom line because it's like the 6 items. And excuse me. It's something here they don't have. We did it. Now I want to see something. Right. I'm sure if that number 1 through 6 was something the bid put on or we put on it. No, the bidder did. It's just an item bid. Yes, look at that. Yeah. Okay. This is an item bid, so prices will not be read. Interboro Packaging Corporation. Good Health Medical Products. I'm sorry. Their name's up to before that. Couple pages back. Should be those up there. It's my B7. And I had the same price, but I don't have B7 in yours. Good Health Medical Products. From what I can tell from the second bid. Excuse me. Everyone's not doing that. The first bid didn't do it. It usually right before and that's their price. Nothing on here. These should even have the gloves. I would just read their name. Government Scientific Source. That was one page for some reason. Excuse me. Veritiv, Veritiv, operating company. Fastenal Company. Midwest Medical Supply Company, LLC.
Refer these bids to the Bureau of Purchases for tabulation and report.
Okay. There being no further business, we are adjourned. So listen now.